Can I relocate with my children after my divorce or after a custody judgment has been entered? Okay, there are 3 or 4 important points that I'm going to address in this 3 or 4 minute FAQ video. So first, can you? Answer is yes, but let's break that down a little bit. First, you can always and very easily and without anybody else's permission relocate 25 miles or less from where you currently reside, okay? You don't need court approval, you don't need your ex-husband or ex-wife's approval. And that's the rule in greater Chicagoland, which is obviously where we are, so that's what I'm going to address here. So the answer is yes, with no strings attached, if you're talking 25 miles or less. Now, step 2, or let's go bullet point number 2 under the yes, you can relocate, is talking about 25 miles or more. You need to do one of 2 things if you want to relocate more than 25 miles away from the other parent. First, he or she, the other parent, can agree to it. And if he or she does agree to it, there's a simple but important notice of relocation form that you need to have each of you sign off on, and then it gets filed in your divorce or custody case in the court system. So call us or check out Illinois Legal Aid online and look for that notice of relocation form. It's generally something you can do yourself, but it's critical you do it because this can't be a verbal agreement. This can't be an email exchange. You got to file that thing in the court date to protect yourself, okay? So that's the easiest way if you want to relocate more than 25 miles away from your current and the child's current residence. Now, what if the other parent doesn't agree to it? Doesn't agree to the move to, Florida or Kentucky or, name it, Mexico, Canada. What if the other parent doesn't agree to it? The answer, now, how do you proceed, I think is really it. You can still get approval to relocate, but now it's a court process, and now you have to get a judge to approve and grant your petition to relocate, okay? So I'm going to spend the rest of the time on this FAQ video basically dealing with, first, how do you win that right to relocate? Or if the shoe's on the other foot, how do you stop the other parent or your ex and the kid from relocating? Okay, these are kind of big answers and I want to keep it short. So here's some summary ideas to just get you thinking, and then let's connect for a greater in-depth consultation. Okay, so how do you win the right to relocate? A court needs to think about this broad question, and I'm going to share some specific examples and some specific cases that we've had. The big question is basically, how does the move make the child's life better? How is the school in the new location better than the school in the current location? How is the neighborhood in the new location better? How is the home better? Think about things along those lines if you're considering a relocation case where the other party does not agree. From working in family law for 16, 17, 18 years, and as a law firm doing only family law, what we have found over that time is that the winning relocation cases tend to fall in, I would say, 3 general fact boxes. And those are the custodial parent gets a significant job promotion. I'm working at a big company with offices all around the United States and the world. And now I've been promoted from, this level to this level. And, my income might double if I move to Seattle. Okay. So the big promotion or the big sort of required job change, that's one of the situations. Second situation, remarriage or a new significant other, generally that whom is living somewhere else. And now that this new union, this other step parent is involved in your child's life, and a lot of times that step parent also, might be employed, where kind of the standard of living is going to be improved. So the job change or the job promotion, the new significant other, partner, spouse, and then the third picture, especially with young children, would be parents break up, whether it be divorce or custody case, and particularly, I think I said young children. Custodial parents' support system, maybe it's their parents, maybe it's their siblings, are in another part of the country, and that support system is critical for living expenses and child-related care. So think about whether or not your situation falls into one of those three boxes, because those seem to be the ones I have seen in doing this a long time now. So that's how you win the right to relocate. Now, final question, how do you stop your ex and the child or children from relocating? Here's the answer, and it's simple, but it's not always easy, and that is you need to be an involved parent, both financially and non-financially. If you're that man or woman and you're really involved in your child's life, a judge is going to be very hesitant to allow another parent to, basically change that important father or mother child relationship from, let's say, living a few miles away to living 1,500 miles away. So, if you're seeing your son or daughter a lot, you're involved in parent-teacher conferences, you're involved in their sports, and you're current on your child support or close to current, that's the best way to defend a relocation case. Let me share one client story, and it was simply that I'm underlining that point. This guy was seeing his kids, if I recall, we were defending against a relocation to California. This guy was seeing his kids 6 out of every 14 days, and he was current on all his financial obligations, and bottom line is the judge denied that relocation. So I'm going to leave it there. So can you relocate? Yes, you can. And can you stop it? Yes, you can. Contact us for a little more in-depth of a consultation, because these are really important and these are really high-stakes win-lose cases.